Rules Committee will come to order, and thank you very much for joining us this afternoon. Today, the Rules Committee will consider H.R. 5233, clarifying congressional intent and providing for the D.C. Home Rule Act of 2016, and S-2012, the Energy Policy Modernization Act of 2016. The Home Rule Act of 1973 granted the District of Columbia a limited form of home rule, specifically the ability to pass legislation on strictly local matters. The act expressly prohibits the district from altering the budget process, and for nearly 40 years there were no assertions that the House Rule Act granted the district the authority to amend the budget process provisions in the act. That is until 2012, when the Council of the District of Columbia passed the Local Budget Autonomy Act, which amended the Home Rule Act to remove the role of Congress in the appropriation of the district's local funds portion of the budget. H.R. 5233 repeals the Local Budget Autonomy Act and strengthens those things prohibited in the House Home Rule Act to prevent the district from unilaterally amending or repealing any aspect of the budget process. This legislation directly benefits the District of Columbia by ensuring that the district's elected officials and district employees are not in violation of the Anti-Deficiency Act and are in compliance with Article 1, Section 8, Clause 17, which expressly grants exclusive legislative authority to Congress over the District of Columbia. The committee also is here to consider S-2012, the Energy Policy Modernization Act of 2016, and a House amendment to the bill. The House amendment contains a wide array of House-passed legislation from the House Energy and Commerce Committee, Agriculture Committee, Natural Resources Committee, and the Science Committees. The legislation directly benefits the American people by modernizing our energy infrastructure, expanding and improving forest management, protecting and enhancing opportunities for recreational hunting, fishing, and shooting, and prioritizes basic science research. Among other things, passage of the House Amendment to S-2012 will allow the Committee of Jurisdiction to begin a conference with the Senate on these important House-passed bills. Today, we have an opportunity to have as our witnesses, and I want to thank both of these members, the gentleman from North Carolina, Chairman Mark Meadows, who will be joining us today, as well as the distinguished delegate, Eleanor Holmes Norton. I want to thank both of you not only for being here, taking your time to represent not only your constituents, but the ideas of your party. Without objection, anything you have in writing will be entered into the record. And I'm going to leave that other stuff alone that's written in here. We'll get into it a lot later. But I thank both of you for being here. Before I defer to the young gentleman from North Carolina, I'm going to allow the gentleman, the ranking member from Massachusetts, an opportunity to have an opening statement. The gentleman's recognized.
I just want to welcome our two distinguished guests, and I will yield back the time so we can get on with the testimony.
Thank you very much. Mr. Meadows, you and I have been dealing with each other over the last day or so on some important issues, and I think the gentleman exhibited not only extreme leadership, but thoughtful ideas on behalf of your role. And I think that you were well balanced and spoken in your arguments to me and on behalf of the issues, and I'm delighted that you're here and the gentleman's recognized.
Thank you, Mr. Chairman, and all of the committee on rules for your attention today, but specifically, Mr. Chairman, thank you for your insight, your leadership on a number of issues, and as we grapple with some of these legislative issues that at times can be contentious, you have been a calming voice and certainly one that whose counsel that I appreciate, so I thank you. H.R. 5233, the clarifying congressional intent and providing for D.C. Home Rule Act of 2016 is indeed a critical piece of legislation. The bill makes clear that the district does not have the authority to grant itself budget autonomy and repeals the Local Budget Autonomy Act of 2012. Now, I would like to note that I do not believe that the Budget Autonomy Act has ever had the force or effect of law, as the council and the mayor has no authority to enact the legislation. The Local Budget Autonomy Act has been involved in litigation at both the federal and district court levels. And while the D.C. Superior Court found that the Local Budget Autonomy Act to be lawful, the only federal court to actually reach the merits of the Local Budget Autonomy Act determined that it was a violation of the Home Rule Act. Indeed, the former Attorney General of the District of Columbia, Irvin Nathan, who testified during the Oversight and Government Committee oversight hearing, that he believed that the courts would ultimately find that the federal district court's ruling to be the most persuasive. And in that, I would have to agree with the Attorney General's opinion. However, given the fact that the Local Budget Autonomy Act creates a real risk for district government employees for potential sanctions under the Anti-Deficiency Act, as you had mentioned, Mr. Chairman, I believe it's prudent for Congress to act now. The bill before us today, H.R. 5233, settles this issue once and for all by repealing the Local Budget Autonomy Act and reinforcing, and I might add, reinforcing the congressional intent embedded in the Home Rule Act. During our hearing, we had a number of witnesses, most of who support budget autonomy for the district, but all of them indeed acknowledged that the congressional intent of the Home Rule Act was to keep this budget authority. And so H.R. 5233 strengthens and clarifies the role of Congress in the district's budget process under the Home Rule Act to really prevent any future misinterpretations. Our recent subcommittee hearing on this issue heard testimony from Jacques Dupuis. He was actually the counsel for the drafting committee of the Home Rule Act of 1973, and Mr. Dupuis made it very clear that Congress never intended to grant district budget autonomy. This was a result of a compromise that was memorialized in a Dear Colleague letter that was circulated by the then Chairman Charles Digg. It was known as the Diggs Compromise. The Diggs letter clearly stated that the budgetary process, that there would be no change in the congressional appropriations role, close quote. So given the historical record that we have, it's unreasonable to suggest that Congress ever intended the district to be able to grant itself budget autonomy. Now, this was made clear, as I mentioned, by the former D.C. Attorney General Irvin Nathan. In his testimony before the subcommittee, he stated that while he supported budget autonomy, the district's process was and remains illegal. In fact, he went so far as to testify that it violates, quote, violates common sense to interpret the congressional intent of the Home Rule Act as allowing for budget autonomy. This is why we're here today. Obviously, the district does not have the authority to simply adjust the federal law as it sees fit, nor does it have the authority to unilaterally enact budget autonomy. Now, the lack of the district's authority to enact a budget or have budget autonomy is clear that 21 times the budget autonomy bill has been introduced in either the House or the Senate. 21 times it's been introduced. 13 of the 21 budget autonomy bills that were introduced were done so either by the current delegate or her predecessor. So every single one of those 21 bills that were introduced failed to pass both the House and the Senate and become law. But I think it maintains the argument that it is this body who can grant budget autonomy and not a local body. And so with that, I would ask that you favorably report out as a result of H.R. 5233 that maintains the congressional intent of our founding fathers, which said that these matters should be reserved for this very esteemed body and this body only. And I thank you for the opportunity to testify, and I look forward to any questions that this committee may have. I yield back.
Meadows, thank you very much. Ms. Holmes-Norton, you're now recognized, ma'am.
Thank you very much, Mr. Chairman, and I thank all members of the committee for hearing us once again trying to defend our rights as American citizens. I am speaking for the Democrats as well, of course, as for myself, and as you might imagine, I'm speaking in strong opposition to the attempt to overturn the budget autonomy referendum, which was voted by 83% of the residents of the District of Columbia. My good friend, Mr. Meadows, indicated that this bill has been introduced 21 times. But let me indicate to him that what the people did, I think, indicates precisely why they moved forward. They looked again at the Home Rule Act, found they could, and precisely because Congress has never taken up the Budget Autonomy Act that has been introduced, they found that they could themselves, through an interpretation of the Home Rule Act, now sanctioned by a court decision, take up and indeed indicate do a referendum to indicate they wanted control over what everybody in this room would declare is a seminal right of being an American citizen, control over the money you yourself raised, not one penny of it, federal money. I have an amendment for this committee to see whether or not my good friend's objection is that the district pass budget autonomy, or whether you want to take the position that a federal entity ought to pass a local budget. I must say, Mr. Chairman, I think it is fair to ask why we are redundantly here today. First thing this morning, perhaps just a few hours ago, the financial services released its own budget. So I wonder if this is a pretense, since they've already said that they're going to do exactly what the words of the bill before you would do, prohibit the district budget autonomy from going forward, and doing so by violating its own rules, legislating on an appropriation. Very anxious to keep the District of Columbia from having jurisdiction over its own local funds. So we are told there's going to be a rider on an appropriation bill, and we're going to vote twice. We're going to vote on a standalone bill. That's how seriously the House Republicans feel about making sure they control $7 billion we raised in the District of Columbia. That's more than many, many states raise. We raise it on our own. No wonder we want to control it on our own. Well, the reason that this matter is already announced to be on an appropriation bill is because the House recognizes that the Senate does not have the votes to overturn the budget autonomy referendum, and it also recognizes that its standalone bill would be rejected by the President of the United States. He has put budget autonomy in his budget also for the last several Congresses. So we are left with a Republican House using federal power against the local budget of a local jurisdiction. I don't know if I should congratulate you or how I should treat this action of your House. It is a bold-faced contradiction of your own most cited principle about containing federal power. Well, as it turns out, the budget autonomy referendum is in effect. So you're going to have to stop it in its tracks. The district is in the process of using the procedures outlined in the budget autonomy referendum to pass its budget for the first time, so that if in fact the House and Senate somehow succeed in overturning the Budget Autonomy Act, it will be the most significant reduction in the district's home rule since it was granted more than 40 years ago. Please understand that what the district had 40 years ago, and still to some extent has, is only delegated home rule. That is to say, the Congress can step in at any moment and, if it had the nerve, and knock it all out. It had the nerve to do that for 150 years. As a child, I grew up in a city that didn't have any mayor or city council, and the Congress sat up here appropriating our local funds. But 40 years ago, actually more than 40 years ago, they passed the Home Rule Act, didn't think that was really right. How is the city acting today? Is it being lawless? It has begun to implement the Budget Autonomy Act pursuant to a court order. And I think what that means, despite the citations of my friend, is that you can, and lawyers indeed have, looked closely at the validity of the Home Rule Act, and they have differed on it. The GAO says one thing, but the Superior Court of the District of Columbia, which is at the moment the latest authority on the Home Rule Act, says otherwise. I want to draw to your attention, Mr. Chairman, that this matter came before the Court of Appeals, Federal Court of Appeals, noting that the lower federal court had overturned the budget autonomy referendum. So here the Court of Appeals for the District of Columbia, the highest court in the city, heard argument, read briefs, turned around and sent it to the Superior Court of the District of Columbia. Didn't say why, but didn't remand it to its own federal district court, but sent it to the local court, which is most in touch with local law, read the Home Rule Act and said this is a reasonable interpretation of the Home Rule Act. As to the compromise Mr. Meadows refers to, let me tell you what the ultimate compromise was in the Home Rule Act. The Senate passed the bill for budget autonomy. That's why they had to compromise. So they used language that certainly leaves room for what the Superior Court found. But I have to say to you, Mr. Chairman, it's difficult to understand what makes Congress so nervous. We leave intact. I mean, so nervous it's passing two different bills to overturn our referendum. We leave intact the authority of this body, Congress of the United States, to overturn everything you want to for the District of Columbia, to repeal part of budget autonomy, to repeal part of the Home Rule Act, to repeal the whole darn thing. So we don't even think that your own power has been abbreviated in any way. The budget comes over here anyway. You would think the budget Congress would never see the budget again. The budget will come over here, and it's almost here, for a 30-day layover like any other bill. So they haven't usurped Congress's authority. They say, okay, you bring bills over here, here's the budget bill over here, you can overturn it. And still you move to preempt a local jurisdiction on proceeding with their own local budget. Mr. Chairman, in 1973, after a very long time, Congress delegated its authority. We're asking you to delegate that authority again if you somehow disagree with the interpretation of the Supreme Court and the government of the District of Columbia. We don't think we are on ground that we are treading for the first time ourselves. Until this Congress, there had been bipartisan support for budget autonomy. I'm not surprised at that my Republican colleagues would be the first to say, look, when it comes to people's money, we really don't want to have anything but their local funds. The last two Republican chairs of the Committee on Oversight and Government Reform, which is the committee of jurisdiction here, former Chairman Tom Davis, former Chairman Darrell Issa, both were not only for budget autonomy, carrying out their own Republican principles, but fought for budget autonomy. I want to read to you just one quote from what Congressman, the former chair of this committee, said recently. The benefits of budget autonomy for the district are numerous, real, and much needed. There is no drawback, end quote. What he meant was that your power remains intact, and yet what the district gets is what any local jurisdiction would want. I'm not sure this committee knows that the District of Columbia pays more to borrow money because its budget has to come to this committee, to the Appropriation Committee, to the House floor, and to the Senate and its various committees. Wall Street doesn't stand for that. They said there's so much doubt, therefore, that you're going to have to pay for it. Is that really necessary? Really want to treat our taxpayers that way? In terms of projections, because we are on your appropriation year, we have to project months in advance of when we have accurate data. And of course, we've had the ever-present shutdown where the district government itself has been shut down for no reason except Congress couldn't take care of its own business. I note and obviously support and very much thank him. I haven't had the opportunity to speak with former Chairman Issa, who has apparently put a bill before you, or has a amendment before you, which would say to the federal government, which would say on behalf of the federal government, you are permanently, the District of Columbia, entitled to keep going doing a shutdown. And I just want to thank whoever is responsible. It comes in the appropriation every year. The appropriation bill on an annual basis has kept the district from being shut down, as the Congress has been threatened with shutdown. Since that happens now, virtually every year, I would certainly ask that Chairman Issa's amendment be made in order. Again, remember, you could always take it back, but we wouldn't be left with that doubt. When the shutdown language exempting us from shutdown on an annual basis first occurred, Wall Street took notice and said so. We noted that, and I ask you to note that and to give us that relief that Mr. Issa has come forward with. My own amendment simply asks you, if you disagree with what the city did, then do it yourself. Do it as two former chairmen have asked that it be done. And finally, I just leave you with your own words on budgetary matters, because the Republican budget this year gave very exalted use very exalted language to describe their deference to local jurisdictions. And your budget spoke on a principled and practical basis, saying we give our states and local municipalities the freedom and flexibility to pursue a reform movement that meets the unique needs and challenges of their communities. We are humble enough, says your budget, to admit that the federal government does not have all the answers. I respectfully request just a little of that humility when it comes to the local budget for the District of Columbia, and I thank you, Mr. Chairman.
Ms. Holmes Norton, thank you very much. The chairman is aware of the arguments that have taken place for a number of years. I remember when we went through this in the Appropriations Committee, we went through this in the Authorizing Committee, and we have been through this. And I would reiterate the gentlewoman is correct. The gentleman, Chairman Issa, did submit an amendment. That amendment will not be made in order. It is not considered in order because it's not germane. It's a very narrow amendment that the gentleman brings today, but I want to look straight at you and tell you that. There was a good bit of debate, and as a matter of fact, you might be surprised at some of the good discussions that did take place with Mr. Issa. Mr. Meadows can speak for himself, but we tried to get to some good discussion, and I think it was held. It will not be represented necessarily in this bill today, but I think progress is being made. Mr. Meadows knows exactly what I'm talking about, and I want you to know how much we appreciate you being here. Yes, ma'am, I think it's a fair thing for you to respect and ask for the things you did, and I think it's fair for me to say back to you, you're darn right. These discussions did take place last night, all through the night, and this morning until about 1 o'clock. Mrs. Fox?
Thank you, Mr. Chairman. I appreciate it. I appreciate our colleagues being here today, and I do understand the differences of opinion that we have on many of these issues. Ms. Norton's been up before, and I'm very familiar with her positions. I'm also very familiar with our Constitution. So I thank both our colleagues for being here. I have no questions.
Thank you very much. Mrs. Slaughter. By the way, she reminded us of her name yesterday, that she intends to win and she slaughters when she does it.
No, I just said they don't call me Slaughter for now.
Okay, well, I'll take it as you wish. I took it the way you meant it.
Thank you, Mr.
Yes,
Chairman.
ma'am.
Thank you both. Mr. Meadows, the prompting you to do this bill, was there some case of malfeasance or that you felt the inadequacy of the district to be able to do its budget, or what? Why are we doing this now?
Thank you for your question. Actually, it's the district who not only enacted a law, but has plans now to bypass the normal process of submitting the budget as it has done throughout the entire time that the home rule has been in place. Indeed, this particular time, they plan to submit their portion of the budget directly to the president, and then from that, as Ms. Holmes Norton had mentioned, bring it here for a state of disapproval. The real problem with that is the Home Rule Act is very specific as it relates to this particular issue. In paragraph 603, it talks about the fact that that budget authority needs to come through the normal appropriations process. And whether you go back to our founding fathers or the debate, we researched the congressional record, and if this is allowed to stand, Ms. Slaughter, what it essentially will do is suggest that the Home Rule Act has no effect, that there is nothing beyond the bounds of an amendment process by a local entity, and that's what brings us here today and why we must act.
Right. And we're only talking about money raised in the district by the district government. Is that correct?
We are, and the gentleman is incorrect. There are specific matters in the charter that the district cannot change
And this is one of
This
those.
is not one of them.
Well, this is section 603, and you're welcome to look it up. Actually, the amendment process is in the 300 paragraphs, and it says what it can be amended, sections 601, 602, 603 cannot be amended by that. And what they've done is used a process where actually the amendment process for other laws were applied across the entire body of the Home Rule Act, whether it be those paragraphs or paragraph 450 as well.
We did, the section you have spoken about was not amended. And this
Well,
is what-
450
this-
was the
this-
other
This
paragraph.
is, yeah, this is what happens. This is really a matter of statutory interpretation. What does it mean? And if you're against home rule, you choose the meaning, of course, that the good gentleman has chosen. But if you're for home rule, you say it's a fair question to offer this interpretation. But so the one thing I wouldn't rely on, Mr. Meadows, is law. The final statement on law comes from a court, the Superior Court, and that court said implement, this court order, implement the Budget Autonomy Act.
Well, I would disagree with my good friend from the district. There was a Superior Court ruling, but it was not a mandate to implement the law. In fact, in her testimony where she talked about the fact that the federal court remanded it back to Superior Court, they didn't judge on the merits of the case. It was considered moot because the mayor had changed part of the argument, and actually it was remanded back. And so as we look at that, there is still a number of legal questions that exist in terms of having to decide those. But I would remind my good friend that it was the previous Attorney General for the district that has said that what the district has done is illegal.
Illegal.
But I wish you wouldn't cite the previous Attorney General, and since the present Attorney General disagrees, and again, we're getting into a back and forth that you cannot win, sir. You cannot win it because on the other side are equally respectable arguments, including the most respectable argument, the argument or the injunction, the court order from the Superior Court of the District of Columbia, which is the only authority in existence now.
You mentioned, Ms. Norton, that because you have to send the budget here, that it costs you money. Would you elaborate on that a little bit for me?
Well, this is the
That
great.
it makes an expense for the district to do that?
This is the great tragedy of it. It costs us money in so many ways. First of all, it bollockses up your operations because you're waiting. Every other jurisdiction, those are my colleagues, you implement your budget July 1st. We got to wait until the Congress on an entirely different schedule implements it. Imagine what that does to your schools. You don't even know until October whether what your school budget really is. Or consider Wall Street. Wall Street doesn't operate on, whether they will pass the budget sometime. The reason they don't do it, by the way, in part is because we've been shut down, because the federal government gets shut down. So they say, we know what we will do. When it comes to borrowing on behalf of the District of Columbia, it's going to cost you more. So there is no doubt but that this body is adding to costs of local government by intruding into a local affair that if it wanted to, it could indeed curtail without, in fact, keeping us from implementing our local budget. This budget, by the way, is not going to the President of the United States. It's going to come directly here for a 30-day layover period. It'll be right here in this House, and you can do what you want to do with it.
Given the fact that we do such a swell job here budgeting in the House of Representatives, do you have ability to do a continuing resolution? Or someone just to tide you over like we do? Maybe do a budget next year, maybe not.
District paid a terrible price when it got shut down a few years ago.
Well, the whole economy, $24 billion went out of this economy with that shutdown. And I'm sure that you were affected probably more than most people because the national facility is here.
Oh, there were, people came from all across the District of Columbia to this house saying, please,
Yeah.
all kinds of payments were held up, all kinds of expenses came forward.
You got some relief from that, though, did you not, from Congress?
We did get very important relief for which I have to thank the Congress of the United States. Seeing what that did to the District of Columbia to be shut down through no fault of its own, every single year appropriators say the District of Columbia budget may go into effect. And by the way, it's next year's budget. This Congress has not been tone deaf. All that can happen on the federal side is that your budget from last year goes into effect if there is a continuing resolution. But even further back, seeing what that meant to local government, to be forced into the prior year's budget, Congress has said, you can go ahead with next year's budget. When the budget comes over here, Ms. Lauder, the Congress does nothing with it. It's incompetent to do anything with it because it would get into the granules of local government. So it kind of just sits here.
It's
And since
just
it
an automatic 30-day wait?
Unless, of course, we have to wait until October the 1st.
in
This way, we would
fiscal
have to
year.
wait only 30 days, and then we could go ahead and implement the local budget.
All right. Boy, thank you very much.
Thank you. Mr. McGovern, do you seek time? That's fine. I'll do that. We're trying to get through our witnesses here.
For all of us first?
Yes, sir.
Yeah, well, first of all, I appreciate you both being here, but I have the same concerns of our ranking member here. You know, this seems like it's being motivated solely by, you know, ideology, and an ideology I disagree with very, very strongly. But it also seems like it's a terribly inefficient way to proceed. You know, budget autonomy. There's no downside to Congress under budget autonomy. Congress can still pass a joint resolution of disapproval if they have any objections to the local portion of the D.C. budget. The D.C. Authorities, I think, have a better sense of what the reality is in the District of Columbia than any of us do up here. They're going to make the better choices. The Constitution, I guess, gives Congress the authority to legislate on any D.C. matter at any time, including D.C.'s local budget, notwithstanding the BAA. You know, budget autonomy takes away the threat of a federal government shutdown that Mrs. Slaughter referred to. And I also, you know, I think it is a little bit ironic that when you think about it, that our Republican friends who can't pass a budget of their own want to make it harder for the D.C. government to be able to pass its own budget. So, you know, I hope that we will make the amendments that Ms. Holmes Norton wants to make in order. But it's frustrating that we seem to have the same fight over and over and over and over again. And I think it really is demeaning to the people who live in the district. And I hope we could at some point in the not too distant future move beyond this. But again, I'm not going to change Mr. Meadows' mind, and I hate to tell you, Eleanor, that if you count this committee, there are 9 Republicans and 4 Democrats. So the chances of us prevailing on anything are a long shot. You know, unless a number of them have to use the restroom during the vote, we're probably going to lose. But I appreciate you being here, and I yield back my time.
Human yields back to time. Judge Hastings, do you seek time? I do. Gentleman's recognized.
12th term in this institution, and I've known Mrs. Holmes Norton for even more years than that. She is a champion not only of the citizens of the District of Columbia, but a champion of civil rights for those of us throughout the United States of America, as well as other legendary undertakings that she has put forward. In those 12 years, you and I, Mr. Chairman, have seen bright spots, I think, when Ms. Holmes Norton actually could vote along with the other people in the territories in the committee And I always felt so good about that. And then when the lights went dark on their names, Ini Falomio Vega from Samoa, I was seated next to him, and a tear just streamed down the right side of his face, largely for the reason that per capita, Samoans died during the war at a greater rate than any community in this country. Same holds for the District of Columbia. And during all those 12 years, what I've seen here is constant experiments, and Mr. McGovern is dead right about the ideological, however you wish to pronounce it, differences, experiments with women's health, with schools, with marijuana. I'm seated next to a gentleman over here from Colorado. His state is flourishing with reference to marijuana. My state is getting ready to vote and I believe approve medical marijuana for the usage of those that are rightly needed. And yet, my Republican colleagues bammed up on this city rather repeatedly. And then the one that really gets me is guns and the experiments that have been ongoing with that. Perhaps we should add a little bit of context. In addition to the citizens lacking, L-A-C-K, voting rights, they also lack full representation, as I'm pointing out here in Congress. They lack control over their own city budget, and they pay more in federal taxes here in the District of Columbia than 22 states in this country. Treated, in my view, like second-class citizens. And what really galls me, and I believe, Mr. Meadows, I really like you. And I mean, people say up here you're friends. I really do like you, and I believe if you and I could sit together for a protracted period of time, I could bring you to an understanding that Darrell Issa came to, Tom Davis before you came to, and countless others. I might add, Ms. Holmes Norton and I knew Charlie Diggs. Charlie Diggs' second wife was my executive in my office when I came here. Charlie Diggs' first wife and I were made federal judges together, and I would ask, please don't cite an attorney general's opinion. It is a good reference, but it doesn't hold the same as a court. There are attorney generals all over the place. I disagree totally with the one in my state. Just about everything she says and does, I'm on the other side of. And therefore, it would serve no useful purpose for anybody to cite that as the law of what my attorney general said. So here's where I believe you are, Mr. Meadows, as well as other friends of mine that are on this panel and throughout the Congress. You all argue all the time, and I find it passing strange, for local control. Now, what city are you from, Mr. Meadows, in North Carolina?
I don't live in a city, I live in a community, but it's
unincorporated?
It's a little
Yeah, you're like me. I live in unincorporated Delray Beach, Florida.
Yours is a little bit bigger than mine. I think mine's
I would
about
think so.
50 people.
I would think so, but in that community, beyond that, or grandfather, where Dr. Fox is from, or let's take Raleigh, or Durham, or Asheville, or any of them.
Sure.
You would argue that they should have local control of their budgets, would you not?
Certainly, when we look at a state versus a city relationship, that relationship has its genesis within the Constitution, as the same relationship of the federal government and the District of Columbia has its genesis in the Constitution. And so those relationships that are not mutually exclusive, whether you look at local control from a states' rights standpoint and the enumerated powers that I think you're referring to, or the district and all legislative powers resting in this body. The genesis of both of those arguments is in the Constitution by
Article
our
one.
founding fathers. So those are actually run on parallel tracks and are not mutually
Just
exclusive.
reclaiming my time for a moment, do
Yeah.
you make a distinction between the federal enclave and
Without a
the
doubt. Yeah, I
district?
think our founding fathers, and really, when you look at Federalist Papers number 43, it said the federal enclave, and that portion, because they're so interrelated, the workings of our federal government and the operation of the city that is around it is a hand-in-glove kind of possibility. And so
it's really interesting to me.
Could I just say, then obviously we shouldn't have home rule.
Yeah, well, that
well,
was where I was
is the gentlewoman in
headed.
favor of repealing home rule?
You seem to be, because you're
No,
citing the founding fathers were saying they were so afraid that there'd be a District of Columbia that they kept all power into themselves. How did we get home rule? Because Congress delegated it to us.
That is correct.
And if you got rid of home rule, perhaps then you're arguing that we ought to have what I think we ought to have, and that's D.C. statehood. 700,000 people live here. I always find it fascinating. All around this city, if we left here, any of us in an automobile driving to New York City, we would pass through enough tolls. You had best not be broke when you leave here going in that direction. Starting in Baltimore all the way up, you pay toll after toll. And people come into this city, and they aren't even permitted in this city to charge $1, and yet people come here and bam up on the roads and leave their trash and all sorts of things, and the city has to deal with that. Now, Ms. Norton has pointed out the details of how it impacts bonding, but I just find it ironic that we're here talking about the District of Columbia's budget autonomy, and we haven't been able to pass a budget here in the United States House of Representatives. I just don't understand how the fact that if they pass a budget under autonomous circumstances and Congress still has the power of disapproval, then what is the problem, and why are we doing this other than for one reason and one reason only? Raw rank power. That's what it boils down to. And it's wrong, and it will continue to be wrong. Now, I believe, way beyond my lifetime, and perhaps everybody in this room, that this city will gentrify. And when it gentrifies and becomes a predominantly white city, and a mostly Republican city, probably, then all of this will be moot. And there won't be any of these discussions. So when you lay it right on the line, I've lived here. I lived here in 1958 until 1961, when this was a segregated city. I lived here when the changes took place, when Charlie Diggs made the compromise. And if Charlie were to be able to morph to life today, I assure you that he would be sitting right there with Eleanor saying that the district should have budget autonomy. I yield back my time, Mr. Chairman.
Gentleman yields back his time. Thank you very much. Mr. Post, do you seek time?
I do.
Gentleman's recognized.
Yeah, first, my colleague, Mr. Hastings, mentioned that the city is becoming a whiter city, and he said a Republican city. But many of the white people are LGBT, and because of the anti-gay agenda that we saw, for instance, an example of on the floor last week, many of them continue to vote Democratic here in the city. Yippee, says Mr. Hastings, but I think until the Republican Party comes to terms with that and can attract LGBT voters, it's pretty safely Democratic here in Washington, D.C. I do want to ask Ms. Norton, what is the plan to make D.C. a state? I mean, I'm tired of you and others coming up here and us micromanaging everything. I don't do that for my home state of Colorado. I don't do that for Florida. I don't do that for Massachusetts or New York or Mr. Sessions' state of Texas. They certainly wouldn't take it very well. What do we need to do to move this statehood thing forward and get you guys admitted as the 51st state, or maybe with Puerto Rico 52nd?
Thank you very, very much for that question. You can imagine if my friends are afraid of a little bit of budget autonomy, they must be terrified at statehood. Nevertheless, we are breaking all records and getting co-sponsors, not one Republican yet, for statehood for the District of Columbia. And what happens to a jurisdiction which is treated like second-class citizens, if that happens long enough, they begin to do what the district did with its budget autonomy referendum, and what now the mayor and the city council are doing with statehood. They found that the state of Tennessee, when it became a state, simply petitioned the Congress of the United States for statehood, and it was granted. And so, the mayor and the city council are now preparing to submit a constitution to the people of the District of Columbia and then petition this body for statehood, using a practice that has been used before. Mr. Paulus, I want to tell you what really broke my heart. No more than, it must be 7 or 8 years ago now, the state of Utah was very distressed that for the first time, the missionaries, which had always been counted, were not counted, and they lost the opportunity to have a seat. This is perhaps the most Republican state in the Union. They joined with the District of Columbia on the theory that this would surely be a wash, one Republican seat for one Democratic seat, nobody would gain. There were a fair number of Republicans who supported this, including Speaker Ryan. I don't know where he'd stand today, but he certainly did support it then. Ultimately, Mr. Davis would never have been, it would never have, unless he chose, rejected by the voters, but he left the Congress. I was not able to get that bill through, not even to get enough Republicans on a Republican-Democratic bill to get one House vote, one statehood. We did get it through the House and the Senate, and some members, Republican and Democrat, deferred to the National Rifle Association, who put an amendment on that bill that said they would wipe out, that essentially would have wiped out all of the gun laws of the District of Columbia in return for the House vote, and so we had to give it up. That's the kind of thing that leads to the budget autonomy referendum, or the petition for statehood.
And I would like to add to that. I mean, those of us who think D.C. should be a state are not trying to say the Democrats should have another seat. I mean, we're happy to expand the size of the House by 2, 437. That's, in fact, it's better to have an odd number anyway. 436 would be an even number, so expand it by 2. I mean, it's really the principle that you have 500,000 Americans, Ms. Holmes Norton. How many Americans?
700,000.
Over 700,000. That's the size of a congressional district. So over 700,000 Americans here who are deprived of being represented here in the United States Congress. We fixed it for the presidency by amendment through the Constitution, but it's a grave injustice to residents who live and work and have families here in Washington, D.C. It's fundamentally the premise of the American Revolution, taxation without representation. And again, this should not be done by any party for any partisan reasons. I think absolutely it's appropriate, as Ms. Holmes Norton indicated, by all means, if we increase the size of the House by 2 or by 5, whatever number you want to, this should balance out. But I just find it every time Ms. Holmes Norton and others, sometimes it's Mr. Chaffetz, sometimes Mr. Meadows, whoever it is she comes here with, frankly, I just feel offended that I have to make decisions for them. I want to defer to her elected government here. It should be a state government. I'm glad they're passing a constitution. I think that's a great first step. That's wonderful. Hopefully it'll pass, and hopefully the statehood application will be acted upon promptly, and the size of this body can be appropriately increased. And I think increasing it is right, because if you don't increase it, you're taking away a seat from another state if you kept it at 435. So, and 436 is an even number, so I think 437 is appropriate. It's not about whether it's another Democrat or Republican. It's about 700,000 people having a full representative here. Ms. Holmes Norton works very hard, but she doesn't have the vote. She has votes in committee. She sometimes gets to do votes, but honestly, I don't know. Sometimes you can, sometimes you can't. But it shouldn't even be a question. I mean, these 700,000 people are the same as the 700,000 people who live in my district in Colorado. I don't understand. They're Americans. I mean, to me, this is very, very offensive. I hope that, and every time, we come up here on something relating to D.C., I'm going to bring this up, but I hope that we can act soon on statehood. I'm proud to support it. I'm optimistic that this constitution that the state will hopefully ratify can be their state constitution, and I look forward to helping however I can to get that through, and I yield back.
Gentleman yields back his time. Thank you very much. Does any Republican seek time? The gentleman from Georgia.
Thank you, Mr. Chairman. I love serving on the Rules Committee because we get to talk about lots of policy ideas. I wish we were an authorizing committee. We actually got to authorize on some of these ideas, but I would just ask you, Mr. Meadows, my friend from Florida, said he hoped one day he could bring you around to the understanding that Chairman Davis had and Chairman Issa had of what what kind of independence could be given to the District of Columbia. I have not understood this resolution at all to be a statement of your opinion on what ought to happen at the District of Columbia. I understood this resolution to be a statement of whether folks have to follow the law or don't have to follow the law. Ms. Norton said if you disagree with what's going on with the Local Budget Autonomy Act, then you should pass legislation to allow local budget autonomy. But I would say that that's not my understanding of the way the law works. Either the law prohibits local budget autonomy, in which case we don't need this piece of legislation either, or it allows budget autonomy, and so we don't need any additional legislation to provide that. The shame of this is not that we're here having this discussion. The shame of it is that the discussion is necessary because the folks aren't allowing the law to speak on its face. Am I understanding that your position, much like the mayor at the time the Local Budget Autonomy Act was passed, Mayor Vincent Gray, Mayor Vincent Gray's position was, I support local budget autonomy, but the way that we are implementing it in the District of Columbia today is against the law. And my understanding of this resolution is that it is not a statement of the merits of local budget autonomy, it's that the way it's being implemented today is against the law. Mr. Meadows?
Well, the gentleman from Georgia's analysis is spot on, and I would suggest even further that as we look at this is a matter of law, and as we have had so many different people that have opined on what it is and what it is not, I can tell you that having worked side by side with a local mayor for the better part of 15 years, I understand the difficulties that a local mayor might face. I have a real appreciation for the current mayor, the current city council, certainly the chairman, but it is a matter of a law that was passed in 1973 that did not provide for anything the magnitude of what has been passed at a local level, violating current law. We have an opinion from the GAO that they believe that this is a violation, if acted upon, of the Anti-Deficiency Act, which would go even further. So you can be totally agnostic on the merits of budget autonomy, but you can't be agnostic on the rule of law and the fact that this is law. This is the congressional intent. It has never been discussed anything other than the congressional intent in 1973 when it was passed, that this power shall remain with Congress. And so your analysis is spot on, and that is why we're here today.
Well, I thought that I heard it suggested that the reason we were here today is because either there's some sort of antipathy towards folks in the District of Columbia, or some sort of massive power grab that folks in Congress are interested in. Why is it that here in the month of May 2016 we're dealing with this when the law was passed almost 4 years ago?
Well, it is, and the gentleman, I thank the gentleman for his question, and where we are today is action on behalf of the local municipality, the mayor and the District of Columbia City Council is changing a process that has been in place since the enactment of the Home Rule. And I might add, this body has recognized over and over again, they can debate the merits of budget autonomy. It has been debated in this body, and indeed, bills have been put forth by my good friend from the District of Columbia to my left here. And in acknowledging that sole power rests within this body. And so to suggest otherwise that it is somehow a power that has been relegated to a local body would set a very dangerous precedent, not only for the district, but for all jurisprudence going forward.
The gentleman seemed to be saying, the initial argument the gentleman seemed to be making would have gone to home rule as well, because for 150 years, after the Republican Congress, right after the Civil War, gave the district home rule, for 150 years, the word was that the Constitution kept us from getting home rule. Then Congress looked closely at what the Constitution said and delegated home rule to the District of Columbia. In its interpretation of the Home Rule Act, the city and the Superior Court take the position that the district could pass a referendum authorizing budget autonomy, and it would be a delegated authority. That's why it's going to come over here for 30 days and rest here.
But I fundamentally disagree with my good friend from the district in taking the context of the home rule when it was passed, and taking the practice of the last 40-plus years, and taking what has been historically the position of this body to allow a local body to change that is exactly and precisely the gentleman from Georgia's point is that what you've done is taken a law that has been clearly understood for a period of time and let a local body make its own interpretation of what it is and what it is not, and that would set a dangerous precedent.
Interpretation has been made by the Superior Court of the District of Columbia pursuant to court order, not just this local body. It's been tested in court.
Well,
To be fair, it has been tested in court. I'm not telling you all anything you don't already know, but every federal court that has ruled on the merits has ruled against the District of Columbia on the merits.
There is no final decision on the merits from any federal court. It was appealed to the Federal Court of Appeals for the District of Columbia. They
Absolutely.
refused to rule on the merits. They remanded it to the local court, if anything seeming to indicate it's a local matter.
It is, the gentleman is right. I would suggest, and I've covered this before, is that it was essentially withdrawn based on the mootness of the argument, not on the merits of the argument that was before that body.
They didn't say why it was withdrawn, sir, and they didn't have to remand it to the Superior Court.
I have great respect for the delegate from the District of Columbia, and I have always admired the way she has fought on behalf of her constituents. And candidly, I believe this institution would be a better place if all 435 of us fought as hard for our constituents as you fight for your constituents. I think that's what's required. It's civility that is required, but it's not a milquetoast argument that's required. It's passion that is required. But I also wish that we would fight as hard for our Article 1, not just our rights and our privileges, but our obligations under Article 1. It seems nonsensical to me that the Home Rule Act that granted the authority of the District of Columbia to appropriate money through the congressional appropriations process would have allowed the District of Columbia to change the rules such that they could drop a piece of paper on our desk at any time the district seemed suitable to the district, and we would be required to act on it in 30 days. It is inconceivable that going through the regular appropriations process could be morphed into a take it or leave it process that someone thrusts upon the Congress.
Could I indicate that you're absolutely right? We can't just pick and choose the things we don't like and then decide to enact on them. There is a charter for the District of Columbia. It's like a constitution. And it indicates very specifically that certain things may not be acted upon by the district. So there are all kinds of laws that the District of Columbia changes every other week because those changes are not encompassed in the charter. This matter was not encompassed in the charter. It is, I concede, a matter of statutory interpretation. But I say to my good friend, your interpretation is certainly not better than the interpretation of the only court to rule on this matter.
I would, my good friend, I'm not here to elevate my opinion above that of any judge or judicial branch. Certainly, it is a separate branch. But I will add that you were part of the hearing, and certainly the Attorney General, under sworn testimony, agreed that the argument that I put forth in terms of it being
What Attorney
dismissed, the previous Attorney General for the District of Columbia.
Not the present Attorney General.
And that it was remanded because it was based on a mootness argument. And so
It
to
never said
suggest.
so, sir. Do not put words in the mouth of the court.
I'm saying.
The Court of Appeals of the District of Columbia can speak for itself.
Reclaiming my time, I would be happy to close if I could, on a note of agreement. I would certainly concede that folks that we all view the facts through our own personal lens. But I would ask you, Ms. Norton, because the seriousness, the gravity with which you always bring issues related here. You mentioned early on in your testimony today, you said if you're against home rule, then you take one interpretation, and if you support home rule, you take another. But whether you're talking about the previous Attorney General or whether you're talking about the previous mayor, you are most certainly talking about folks who support wholeheartedly home rule, but who still agree that the district did not have the ability to pass this Local Budget Autonomy Act. Again, I'm willing to let the votes fall where the votes fall, and folks can disagree about the facts, but I don't want to suggest that this is a debate that is motivated by politics. As much as it is a debate that's motivated by a legal interpretation, and at the end of the day, those things matter. Would the gentlelady concede?
I certainly would, and I have conceded all along that honest lawyers can have disagreements. That's why I have repaired to the court decision. Now, and that is where we rest now. I do understand that even within the district, the disagreement was, what would the Congress say? And one administration said, well, the Congress would say no, and that's who has the power. And the other administration said, the Congress would say no, but let's look more closely at this bill. And then they found that lawyers on either side were in disagreement. If you had struggled for almost 200 years to get the most basic of respect from the Congress of the United States, and you knew that there were split among lawyers, surely you would go forward to try to see which side are you on, to quote the old spiritual.
Well, given that the Article 1, Section 8 gives the Congress exclusive legislative jurisdiction here,
Conceded.
we are lucky to have folks of your intellect and both passion and compassion working on these issues. I thank you both. Mr. Chairman, I yield back.
Gentlemen, yield back this time. Does any other member seek time? Seeing none, I want to thank both of our members from being here. I want to thank them for their time and their assistance and help us work through this issue. And I want to thank both of you very much. And
Thank you, Mr. Chairman, and thank this committee.
Yes, sir. Okay, we now have heard the debate, H.R. 5233. And this will close the hearing portion of that hearing. We will next move to S2012. I'd like to advise the committee that I did not seek or solicit testimony because all these are bills that have passed the House previously. This closes the hearing portion of S2012, Energy Policy and Modernization Act of 2016. Chair will now be in receipt of a motion from the gentlewoman from North Carolina.
Thank you, Mr. Chairman. I move the committee grant S2012, the Energy Policy Modernization Act of 2016, a closed rule. The rule provides 1 hour of debate equally divided among and controlled by the chairs and ranking minority members of the Committee on Energy and Commerce and the Committee on Natural Resources. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-55 shall be considered as adopted, and the bill as amended shall be considered as read. Rule waives all points of order against provisions in the bill as amended. The rule provides one motion to commit with or without instructions. Section 2 of the rule provides that if S 2012 as amended is passed, then it shall be in order for the chair of the Committee on Energy and Commerce or his designee to move that the House insist on its amendments to S 2012 and request a conference with the Senate thereon. Section 3 of the rule provides for consideration of H.R. 5233, the clarifying congressional intent in providing for D.C. Home Rule Act of 2016 under closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. Rule waives all points of order against consideration of the bill and provides that it shall be considered as read. The rule waives all points of order against provisions of the bill. The rule provides one motion to recommit. Section 4 of the rule provides that on any legislative day during the period from May 27, 2016 through June 6, 2016, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair and declaring the adjournment. Finally, Section 5 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 4.
Now heard the motion for the gentlewoman from North Carolina. Is there amendment or discussion to that?
Yes, I do. Thank you, Mr.
Gentlewoman's
Chairman.
recognized.
Mr. Chairman, I have an amendment to the rule. I move the committee make in order, give the necessary waivers for the amendment to H.R. 5233 by Congresswoman Norton. Number 1, which would grant the District of Columbia budget autonomy by act of Congress. I urge a yes vote on this. This has gone on far too long, and I think that they deserve, if there's 700,000 of them there, they deserve the same kind of citizenship as all of our constituents have. And certainly they should not have to be bothered every year by this nonsense about having a budget come up here to sit around. We have budgets up here sitting around far too many, and I don't know that I want to take on District of Columbia's. So I urge a yes vote.
Thank you very much. Further discussion? I think we've heard the debate that was not only well-rounded on both sides, but the articulation of the United States Constitution. Those in favor of the Slaughter Amendment signify by saying aye.
Aye.
Those opposed, no.
Roll call,
Noes have it.
please.
Gentlewoman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion? Gentleman from Massachusetts.
Yeah, Mr. Chairman, I'd like to ask unanimous consent to insert in the record the statement of administration policy.
Without objection.
On H.R. 5233, which says if the President were presented with this bill, his senior advisor would recommend that he veto the bill. And I have an amendment to the rule. I move the committee grant H.R. 5233 an open rule so that all, and also move the resolution make the House amendment to S. 2012 subject to further amendment under an open process so that all members have the opportunity to offer amendments on the floor.
Thank you very much. Discussion? Vote now be on the McGovern amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Ask for roll call.
Gentleman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Aye.
Mrs. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 6 nays.
The amendment's not agreed to. Further amendment or discussion? Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor of the motion signify by saying aye.
Aye.
Those opposed, no.
No.
The ayes have it, the ayes have it. Accordingly, the gentleman,
I need this coffee.
Dr. Burgess, will be handling this for Republicans.
And I have that pleasure for the Democrats.
Thank you very much, Mrs. Slaughter, for the Democrats. Before we conclude today, I have one more piece of business for the Rules Committee. That objection that the chairman lays out before the committee, a committee resolution, and asks for its immediate consideration. Clerk will report the resolution.
Resolution expressing the gratitude of the Committee on Rules to Mr. Miles M. Lackey, the committee's Democratic Staff Director, for his service to the committee, the House, and the nation on the occasion of his retirement from the House of Representatives. Whereas Mr. Miles M. Lackey has served the nation in both the legislative and executive branches over the course of nearly 3 decades. Whereas he has served the Committee on Rules for most of his career, first as an associate of the Rules Committee staff, then later as senior advisor to the chair, and both majority and minority staff director. Whereas during his career he has brought competence and dignity to each office he has held. Whereas his advice and counsel are sought by both members and staff alike. Whereas he has always endeavored to ensure the effective operation of the committee, even when the majority and minority differed on policy or process. Whereas his good humor and steady demeanor will be missed. Now therefore be it resolved that, 1, the Committee on Rules expresses its profound gratitude to Mr. Miles M. Lackey for his exemplary service, and 2, the clerk of the committee is hereby directed to prepare this resolution in a manner suitable for presentation to Mr. Lackey.
The chair recognizes myself for a brief moment to explain the resolution. Today is Miles Lackey's last day at the Rules Committee. I don't know if this is his last Rules Committee meeting, but this is his last day at work. Miles, I will say this, I don't know if you'll miss us, but we will miss you. And I was most pleased as I heard about your future, what it entails, the exciting part of what it would be. And I must tell you, while I have not turned to thinking about my future much, yours sounded exciting. For your service to this committee, for your friendship to all the members, for your professional demeanor, and always for your support of not only your members, but your party, but perhaps more importantly, for trying to do the right thing and make things work and work well. Mr. Halpern, I will tell you, has always thought the world of you. I have thought you served not only ably and well, but I thought you were smart and well-balanced. So I think that what we're trying to say in this resolution today is you earned your pay every day. You were faithful to not only what your service was about, but I think you could look at yourself in the mirror every day and know that you did a good job. Now, that's what I think. I want to defer, if I can, to the gentlewoman from New York for her own ideas about this before we decide we're going to be for this resolution. Gentlewoman's recognized.
Thank you very much, Mr. Chairman, and I thank you for your graciousness in doing this for Miles. I've always felt that the nicest thing about being on this committee is that the staff on all sides is so wonderful. I always felt close kinship to pay attention to what everybody's doing and thinking, and they always, on both sides, the staff up here is extraordinary, and we've been very lucky to have them. Miles and I came to Congress at about the same time, and I knew about him immediately because he was always all over the floor. Every time I looked up, he was there directing something. And of course, he was just at the outset knew almost everything in the world there was to know here. I'm sure that he reads with the Jefferson Manual on Rules every day and understands all that. But you'd be surprised at how many people in the Rules Committee have come up to me on the floor and asked if they could borrow Miles. And we decided that since we didn't believe in indentured service here, that Miles could go ahead and make his own arrangements on that. He has been extraordinarily generous. Freshmen coming in and things that they learn from Miles, they want to be where he is. He's given himself to every single thing that we have tried to do here. He is steady. one of the most wonderful things you can say about a human being is he's totally responsible, always doing his job cheerfully. I've never known him to lose his temper at anything or anybody. He has left such a mark. He got in the House of Representatives. We went through with numbers of bills that he was here, always willing to work all the way into the night, whatever it took. Miles never complained about a thing. And when you mentioned Hugh was sort of his partner. They were good friends together. He never told me anything you said, Hugh, but I knew that you guys were talking a lot. But he is going to be so sorely missed, and I don't know if all of you know what he's going to be doing. He was going to go to North Carolina. He was building a house in Raleigh in the woods. And I said to him one day, Miles, you cannot go back to Raleigh and sit in the woods. So he has a theology degree from Yale. And he went to New York City, had a good friend there at Trinity Episcopal Church. And if you remember, that was the little church that suffered such damage at 9/11. And he will go work there now 3 weeks a month of outreach to the Episcopal Church and atoning for everything he did here, I think. And then 1 week he gets to go and live in the woods in Raleigh. I hope he will come by here when he makes those trips back and forth. I have counted on him, not as somebody who worked with me much more than that. I've counted on him for his counsel, for his friendship, for the fact that, as I said a while ago, he is as steady as a rock. We may not see his like again, but we are proud to have known him, proud to have worked with him, and we know that he is going to be sorely missed. Thank you all very much for this tribute to Miles. I'm grateful, and I know he is. In fact, he's probably, no, he's not. Look at that. I expected a tear. I mean, I thought we did right well for him, didn't you? Oh, thank you so much, Mr. Chair, for your kindness. Thanks.
Well, I would defer to anyone in the committee that would choose to give any statement about Miles. This is not a character reference, Miles.
Yeah.
Mr., is this the roast, Mr. Chair?
Well, before we decide that we're going to go through with any resolution, I think it's only fair the gentleman from Massachusetts recognized.
Well, thank you, Mr. Chairman, and I want to thank Miles for being the inspiration for a resolution that I can finally support in this committee. And that in and of itself is a great achievement. He's going to the Trinity Episcopal Church, and I said to him, I'm not an Episcopal, but, I could be an altar boy, I could do something. Well, probably not, I'd be, but he's going on to do actually very, very good work on behalf of populations that don't always get a lot of attention, a lot of support from places like this. But I've known Miles, we both were staff members together many, many years ago. I've known him when he worked for Tony Bielenson and for Ted Weiss and for Dave Bonyer and then for Senator Edwards and, as well as the Rules Committee and Chris Dodd.
Mm-hmm.
I mean,
He's there for Dodd.
and he is, he's been involved in a lot of issues that are near and dear to my heart. But he's not only been an extraordinary public servant, I think more importantly, he's a very, very good man, and we're all going to miss him here. And we wish him well. But I agree with Louise that sometimes we take for granted the good people that we have here, and we should never do that. And Miles is not only good; he's been exceptional. So I wish him well, and I'm jealous. I yield back.
Yes, sir. Judge Hastings?
Thank you very much, Mr. Chairman. Mr. Chairman, I didn't know Miles's background until I learned that he was getting ready to leave, and I didn't know about his background in theology. So, Miles, I offer my apologies for all the cursing that I did, and ask you to ask the Lord for special dispensation in that regard.
If you'd known that, would you have been different?
But I concur with everything that the chairman and ranking member and my good friend, Mr. McGovern, have said. And certainly it has been a pleasure indeed to work with you and Hugh. And I know that you will ultimately miss us, but perhaps not as much as we will miss you. Thank you so much for your service to this institution and specifically to this committee.
Thank you very much, Judge Hastings. I would defer to one of your soon-to-be North Carolinians at this time. The gentlewoman is recognized.
Well, I wanted to claim Miles a little bit. I know it's been mentioned that he's from North Carolina, and not too far up from outside my district. He's from Cleveland County, which is a nice place. And I wanted to say thank you to Miles for his good work here. He always has been very friendly and cheerful and easy to get along with. And I agree with Judge Hastings, Miles. You will be missed. Thank you very much. And we welcome you back to North Carolina.
Mr. Polis?
Just wondering if we can just deem it passed rather than pass it, in celebration of how clever he is with the rules. I had the opportunity to talk about him on the floor today to millions of C-SPAN viewers across the country. Very honored to do so, along with my colleague from Georgia, and I'm happy to yield back.
Thank you very much. Does any Republican, the gentleman from Georgia?
Mr. Chairman, Dr. Burgess and I were just wondering if there was a statement of administration policy on this resolution before we move forward.
A good question.
But given
Oh, I seem to have one here somewhere.
it is a sad thing. I think that many folks don't realize what an amazing opportunity we all have as members and staff until it's too late. And what I have always enjoyed about Miles is that I believe that every day he absolutely believed that he had an extraordinary opportunity to make a difference, and did not let one of those days go by. And that's a model that we can all strive to emulate. So, thank you for your service.
Very nice. I'd like to associate myself with your comments and all the comments that have been here today. Does any other member seek time? Gentleman from the beautiful state of Washington.
Thank you, Mr. Chairman. I would just postulate that perhaps Mr. Polis wants us to not vote because he never has voted yes in this committee. I'm not sure. But at the risk of being repetitive, this is a committee that is, I think every one of us looks forward to coming, sometimes more than others probably, but this is a very enjoyable experience here, if I can say so. And part of the reason for that is because of the helpfulness and the cheerfulness of the staff. And I don't know of any day, I can't think of any day that Miles didn't have a big grin on his face. Just always a very pleasant individual. And so I just wanted to thank you for contributing to making the Rules Committee a very pleasant place to work. So thank you, Miles.
Very nice. I would say, since I can sometimes speak for the management, that Miles has been most fair and supportive. He knows that all of us live in glass houses, that we have things that sometimes go our way and sometimes don't. But Mr. Halpern, every day felt like he had a person that he could not only confide in, console with, but work with. And Miles, you lived up to that. And that is a pretty rare thing where teams that have ferocious members as we do would find that commonality. And I think that you should know that you did a good job and move forth with the confidence in the rest of your endeavors that you can be very successful, and we thank you also. If there's no further discussion without objection, the previous question is ordered, and the question occurs on the resolution. All those in favor say aye. Aye. Those opposed, no. The resolution is agreed to. Congratulations. Very, very nice. I will make sure that we've got this available for our awesome stenographer. This completes our work for the day. I believe, Mr. Halpern, that we have completed all the work that was required. Thank you very much.
Thank you. That was very nice. Appreciate it. Now I'm a little worried about this guy.
What did I do now?
No, you're as nice as can be. I do actually